we didn't have any chair's announcement. Coordinators approved the proposed draft agenda for 2021 September of this year. Proposals for future meetings. Coordinators agreed to close petition number 482 of last year. Coordinators agreed to include petitions number 195 of this year, 1,118 last year in the agenda of October. Coordinators agreed to include petition number 146 of this year in the agenda of November. Coordinators agreed to include petitions number 1,078 of last year, 594 last year, 353 this year in the agenda of September. Coordinators agreed to apply the urgency procedure to petition number wait a minute, I was here, no? Yes. Coordinators agreed to apply the urgency procedure to petition number 604 of this year to include in the September agenda. Coordinators decided to apply the urgency procedure to petition number 574 of this year to include in October agenda. Coordinators agreed to include petition number 1015 last year in a future agenda. Coordinators agreed to apply the urgency procedure to petition number 628 this year and to include it in September agenda. Coordinators did not agree to include petition number 166 of this year in the agenda of September. Coordinators decided not to deal with the request of MEP Dancy to include petition number 480 of 2018 in the agenda of September or October, and decide to inform non-attachment MEP of the following options. No attachment MEP can ask one of petty coordinators to take over their request for the coordinators' agendas, or non-attachment MEP can put forward their request for adding petitions to future agendas during the petty committee meetings. About the point 5, coordinators agreed to close petition number 814 of last year, 884 of last year related to Pegasus on the basis of the recommendations adopted by Parliament. Coordinators decided to close open petitions on Jugendamt from 2013 to 2022 on the basis of the petty report on the fact-finding visit to Germany and the functioning of the Jugendamt. Coordinators agreed to close petitions number 1093 of 2018, 872, 862, and 889. The last ones, it was from 2018, and the last one, 889 of 2021. Okay, coordinating the point 6, coordinators endorsed the draft program of the Interparliamentary Committee meeting, which will take place on 20 September of this year. Point 7, petty coordinators agreed to reply to employment letter along the following lines. Express petty's discontent for the employment reply that does not address petty's concerns. Recall petty's involvement in disabilities issues and in the United Nations framework and the need to take due account of it when dealing with questions related to disabilities. Ask employ to clarify how the disability rights coordinators would be appointed. Insist that petty be associated in implementation and mainstreaming report. About the point 8, the coordinators agreed to keep open petitions number 98, 2015, 1134, 2015, 742, 2018, and add them to one of the forthcoming meetings. Coordinators took note of the B item petition 623 of 2018 from June agenda request to be kept open, for which the petitioner has 2 months time to provide additional information. Coordinators took, in point 9, coordinators took note of the new Bureau decision governing the participation of interest representatives in events held on European Union premises. Point 10, coordinators took note of registration of a new ECI entitled Taxing Great Wealth to Finance the Ecological and Social Transition. Point 11, coordinators took note of the reply received. And point 12, no business, no other business. So thank you very much. Nobody's saying anything, so it means that all these outcomes are approved. Now, we are going to the public hearing. First of all, distinguished experts and honorable colleagues, members, it is a real pleasure to welcome you to this public hearing on Schengen borders, issues raised by petitioners, organized by the Committee on Petitions, in association with the Committee on Liberties, Justice and Home Affairs. So for me, it's a pleasure to join this chair with Paulo Rangel, Vice President of LIBE. I would like to warmly welcome all the participants and particularly our experts, Ms. Corina Ulrich, Mr. Stefan Salomon, Ms. Eles Gil, and Mr. Fabian Gulzau, and all the members, the audience, and the staff present in the room, as well as remotely. The Committee on Petition has recently examined and discussed a number of petitions complaining about internal borders control among member states belonging to the Schengen area, including temporary borders between Denmark and Sweden, between Denmark and Germany, between Germany and Austria, as well as petitions on the extension of Schengen area. Debated petitions pointed also to the cases of blocking borders crossing on the grounds of public health concerns regarding COVID-19, such as the separation of spouses in Germany and France, as well as general movement limitations in Belgium. Considering the number of petitions received on this topic, the Committee on the Petitions decided to organize a hearing to give voice to citizens' concerns over the reintroduction of border checks between some member states, thus limiting the free movement of persons within the European Union. The hearing will consist of two panels. First, we're starting for the panel one. Panel one on Schengen historical background, and the second panel is on internal border controls. In the context of the time constraints of one of our speakers, Ms. Gil, the first questions and answers session will take place under panel 2 immediately after her intervention, covering also the panel 1. In the framework of panel 2, we will also listen to the presentation of Ms. Sylvie Guillaume, the LIBE rapporteur for the draft report on the proposal for a regulation of the European Parliament and of the Council amending regulation 2016-399 on a union code on the rules governing the movement of persons across borders. The concluding remarks will be presented by Mr. Paulo Rangel, chair of the Schengen Scrutiny Working Group in Libya. So, without further delay, I would like to give the floor to the experts in the first panel to present the issue of Schengen historical background. Please let me remind you that you have 10 minutes for each of your contributions. And I'm very pleased to introduce Ms. Corina Ulrich, Head of Unit of Schengen and External Borders in DG Immigration and Home Affairs, Director B Schengen, Borders and Visa at the European Commission, who will present this first part of the panel. So thank you, welcome, and 10 minutes.
Thank you very much, Chair, honourable members. Thank you for the invitation to today's panel and the possibility to look back at Schengen and look at today's situation in Schengen. Today, around 425 million people enjoy the freedom, the security and justice that Schengen offers. Schengen is the largest area of free movement without internal border controls in the world. Following the 8th enlargement with the accession of Croatia on the 1st of January 2023, the Schengen area comprises 27 European countries that had formally abolished their internal border controls. I recently attended a conference which was organized here in Brussels and which was called Schengen Quo Vadis. Participants were mainly academia and retired EU officials who actually recalled how it all started. So exactly the subject that I'm dealing here with today. And some of them referred to the Benelux cooperation, which to a large extent is reflected in the wording of the Schengen Convention because it already existed at the time between the Benelux countries. Others pointed at the French-German cooperation launched and the determination of some politicians, and to name just two, François Mitterrand and Helmut Kohl, to give a new boost to the local initiatives concerning the measures applicable at the internal borders. I was actually last autumn in Schengen, and there was a guided tour, actually guided also by a retired EU official. And he said in 1984, Helmut Kohl and François Mitterrand were standing at the bridge that connects Strasbourg and Kiel. And they were looking at these long queues of cars, of commuters that were standing there in the traffic jam waiting to cross the border. And they said, our economies cannot afford this. They are losing so much money. People are losing so much time. We should find a solution to this. So these are two of the parents, but we know that all success stories have many parents. And the same is the case for Schengen. In 1985, only 1 year later, on the 14th of June, 5 European countries met on the Princess Marie Astrid, a boat that is still there in the canal in Schengen. And they agreed to gradually abolish checks at the borders between them. And this was when the Schengen area was born. Since 2022, we have been producing a yearly State of Schengen report. In this year's report, which was adopted by the Commission on the 16th of May, we record some of the most emblematic indicators proving the point how great an achievement Schengen is. In 2022, 65% of world tourists who traveled internationally came to Europe, making Schengen the most attractive and visited area in the world. Beyond facilitating travel within the Union, Schengen is a key driver of competitiveness for European businesses. Schengen substantially contributes to the well-functioning of the single market, accounting for 23 million businesses and 15% of global GDP. And this is exactly what the founding fathers had in mind when they thought our business will benefit if they don't stand in the queue. This is a truly impressive result. However, it took time and determination to get there. Article 2 of the Schengen Agreement was still relatively modest. It states, with regard to the movement of persons from 15 June 1985, the police and customs authorities shall, as a general rule, carry out simple visual surveillance of private vehicles crossing the common border at reduced speed, without requiring such vehicles to stop. So it was basically kind of making the controls lighter, but not abolishing them altogether. Only in the long term, the founding fathers of the Schengen area expected the parties of the agreement to abolish checks at common borders altogether, while transferring these checks to the outside border of the EU by strengthening these checks at the external borders. Furthermore, what we saw then was also a set of measures to strengthen the Schengen area within, so measures that complement the protection of the internal borders. And this is set out in Article 17 of the Schengen Agreement. Almost 40 years later, we have generations who do not recall Europe with internal border controls. They have been born when these internal controls were long abolished, and actually they could not imagine, I think, to live in a Europe where you would need to show your passport when you cross the internal borders. Tellingly, the same Article 17 of the Schengen Agreement that I mentioned before pointed at the need to harmonize in the first place the laws, regulations, and administrative provisions concerning the prohibitions and restrictions on which the checks are based, and to take complementary measures to safeguard internal security and prevent illegal immigration by nationals of states that are not members of the European communities. Harmonization of laws, regulations is therefore the very essence of Schengen. And Schengen is only possible thanks to these complementary measures. Historically, the first breakthrough in the process of Schengen emerging on maps and political agendas came in 1990, with a convention implementing the Schengen Agreement, which is at the origin of many pieces of legislation to which we are referring in our work on a daily basis. The Schengen Borders Code, the Visa Code, the Return Directive, and others. So this all came from the Schengen implementing convention, and then developed into separate pieces of EU law. Another breakthrough came with the Treaty of Amsterdam and the incorporation of Schengen into the law of the European communities. And this created what we call today the Schengen acquis. The need to respect the special position of Denmark, as well as Ireland, and at the time, of course, the United Kingdom, led to the so-called géométrie variable, where we have the Schengen acquis that applies to a different set of countries than the actual EU law. The Treaty of Amsterdam, then, meant replacing the intergovernmental method of cooperation by a more European one, where each of the provisions or decisions which constitute the Schengen acquis had to be linked with the legal basis in the treaties. Thanks to this process, which was continued in the Treaty of Lisbon, we can all contribute to preserving Schengen, as we are all playing a role in making sure that the complementary measures are functional and keep up the pace with the changing world. And we have to acknowledge that Schengen is not only a great achievement, but it can also not be taken for granted. Maintaining Schengen as we know it is hard work, and that needs to be done every day. The crisis of the last few years, be it in the area of migration, be it COVID-19, as you already mentioned, Chair, have shown that Schengen is not something that runs by itself, but something that we need to work continuously on, that we need to improve, that we need to adapt, and in order to make sure that it remains as we know it. At the same time, Schengen is not only complex in legal terms, but also politically. It is very often linked with the challenges related to asylum policy, even if years ago Schengen and asylum policy have actually gone separate ways, thanks to the géométrie variable. Without denying the fact that both are rooted in the Convention, we have to respect this separation when we discuss our secondary law related to Schengen. This political complexity is also visible in the context of the enlargement process, where a number of issues influence the decisions of the member states when discussing in the Council the decision on lifting controls at internal borders. Despite this complexity, I'm confident that Schengen will be even more prosperous with the inclusion of Bulgaria and Romania. The Commission strongly commends the efforts of these two member states that have used many opportunities to demonstrate their full commitment to the Schengen project. We are closely working with the current Spanish presidency in the Council so that a decision for the Schengen accession of Bulgaria and Romania can be taken this year, building on the important political steps taken already last year. Thank you very much.
So first, I'd like naturally to welcome all of you and to say that it is an honor to be here as President of the Schengen Scrutiny Group and on behalf of our Committee President López Aguilar, Juan Fernando López Aguilar. And so I'd like to thank now Mrs. Ulrich for this historical insight about Schengen that also shows how important it became for all of us as European citizens, and especially the ones that are in Schengen and also European citizens that are not in Schengen area, but naturally profit a lot from it when they are in Schengen territory. Now I would give the floor to our second expert of the panel, number one, Mr. Stefan Salomon, who will present the topic Assessment of the Current State Play of the Schengen Area, Strengths and Weaknesses. Extension to other countries, including Romania and Bulgaria, the cost of non-Schengen. So now I would give the floor to Mr. Salomon for, I'd say, around 10 minutes. So.
Thank you so much, Monsieur Rangel, for giving me the floor. So I've been, as you mentioned, I've been basically asked to address 3 points. First, the current state on the reintroduction of border controls, so the current state of Schengen. Second, what are the economic costs of maintaining these controls? Third, the full application of the Schengen acquis to Bulgaria and Romania, focusing again on internal border controls. I guess these 3 points would be enough to fill an entire afternoon, but I will try to do this in the next 10 minutes. And just to be clear, I will talk about these points as a legal expert, so from a legal perspective. As to the first point, the current state of Schengen. So the legal, if we talk about Schengen, the legal and normative core of Schengen is the very area without internal border controls. And it is exactly this core that has been undermined and still is undermined since 2015, when the first member states reintroduced controls and that still maintain controls due to back then the terrorist attacks in France and the increase of asylum seekers in a couple, the number of asylum seekers in a couple of member states. 3 points, and let me illustrate this this undermining of the legal and normative core of Schengen with 3 points. First, the number of controls rose considerably. In the first 20 years of Schengen, from 1995 to 2014, member states reintroduced controls a total of 90 times. Since 2015, this number rose to 369 times. This is an increase of more than 600%. Second, the duration of these controls is also longer. Before 2015, controls were reintroduced for a few hours to a maximum of 4 weeks. Since 2015, most member states reintroduced controls for 6 months at a time and then continuously prolong these controls. The third point that illustrates this crisis of Schengen is that the nature of the reasons that member states provide for reintroducing controls changed. The Schengen Borders Code requires the existence, and I quote, a genuine, present and sufficiently serious threat that affects one of the fundamental interests of society, end of quote. Prior to 2015, member states reintroduced controls because of concrete threats. These threats included sport events, political summits, or the meeting of the Icelandic chapter of the Hells Angels motorcycle club. In 20 years, migration, so from 1995 to 2014, migration was only used 4 times as reason for reintroducing controls. Terrorist threats were used only 10 times. This changed fundamentally since 2015. A common feature of the controls, or rather of the notifications that member states send to the Commission, is that they all emphasize risks, that is, potential risks rather than concrete threats. The upshot of this development since 2015 is that border controls are turned from exceptional measures that are used only on a temporary basis into instruments of risk governance that are employed on a quasi-permanent basis. In principle, the Court of Justice put an end to this practice. In April of last year, the court held in its decision in Landespolizeidirektion Steiermark that unless there is a new threat to internal security that is different in nature from the previous threat, member states are only permitted to unilaterally reinstate controls for a maximum of 6 months. Although this judgment by the court is binding on all member states, they do not implement it. Judicial checks in the member state by member states' courts are also failing. In France, the Conseil d'État held that the prolongation of controls by the French government would be in accordance with EU law. The Conseil d'État thereby adopted an interpretation that is flatly contrary to the judgment of the Court of Justice. This brings me to my second point. So what if member states maintain these controls since 2015? Well, it's 5 member states which maintain these controls since 2015. What are the economic costs of these prolonged reintroductions? Well, if we look at the existing studies on economic studies on the costs of these controls, there are a couple of studies out there. So the scientific service of the German Bundestag, for instance, enumerates alone 4 studies that exist in Germany. There are 2 studies that have been commissioned by the European Parliament and at least 1 study by a French government institution, France Stratégie. All of these studies differ both in breadth and in depth. However, what they do have in common is that they all basically come to the conclusion that controls at the internal borders result in significant direct and indirect costs. I'm pretty sure that many of you will be familiar with at least some of these studies, so I don't want to rehearse all of the findings in these studies, but I just want to highlight some or give you some concrete examples of the indirect costs on free movement of goods and services. To my knowledge, most exhaustive study by the IFO Institute at the University of Munich estimates that controls at the German-Austrian border alone would result in a reduction of the import of goods and services by 0.5 percentage points a year. in Germany that is equivalent to a sum of 6.3 billion euros a year. To give you another example, at the Austrian border, there are on a daily basis more than 51,000 EU citizens who commute from Hungary into Austria, and more than 14,300 EU citizens who commute from Slovenia into Austria. Those are the most recent data that I found from Statistics Austria. Based on an estimated 10 minutes waiting time for one crossing at the border, the indirect costs for these union citizens would amount to more than 47 million euros a year. I assume that similar studies exist for commuters in Denmark and Sweden. Let me come to the direct costs now of border controls. In Austria, direct costs for border controls amount to 88 million euros in 2021. And these are mostly costs that are related to personnel costs. One remarkable thing about the direct costs is that, to my knowledge, in none of the member states, data on direct costs for the prolongation of these controls are publicly available. This, of course, raises transparency issues. From a legal perspective, the point about these economic costs is that each time member states reintroduce controls and send notifications to the Commission, these costs would need to be part of the proportionality assessment, so as to measure or at least to weigh the impacts and the effects of these controls on the free movement rights of citizens and companies in the EU. Virtually none of the notifications that were sent to the Commission since 2015 basically included such costs. This brings me to my final point. The full application of the Schengen acquis to Romania and Bulgaria. Bulgaria and Romania are already fully bound by the Schengen acquis. Only parts of the Schengen acquis do not yet fully apply to Bulgaria and Romania, especially the part on the abolition of internal border controls. The full application of this part of the Schengen acquis is basically a two-step procedure. First, an evaluation must be carried out that the necessary conditions for the application of all parts of the Schengen acquis are met. Second, an unanimous decision by the Council must be adopted with the consultation of the European Parliament. The Schengen evaluation report, so that's the first step, stated already in 2011 that Romania and Bulgaria are sufficiently prepared to fully apply the rules of the Schengen acquis. The Council decision, however, was not adopted in 2022 due to the veto of Austria and the Netherlands. And it is interesting to look at the reasons that the Dutch and the Austrian government give. So the Dutch government argues that Bulgaria must, and I quote, Bulgaria must implement all the necessary measures, rule of law, fighting corruption, independent judiciary, end of quote. In a similar way, the Austrian Chancellor cited the dysfunctionality of the Schengen area as a reason for not extending the Schengen acquis. This basically, from a legal perspective, this basically raises the question, so what are the legal criteria for full application of the Schengen acquis to these countries? Are they fixed criteria or are they rather adaptable, as the Austrian and Dutch government suggest? Well, a look at Article 2, a look at Article 4.2 of the Act of Accession basically indicates that this provision only refers to the Schengen evaluation as the basis for the verification by the Council if the conditions for a full application are met. The specific criteria are then determined by the Schengen evaluation body. This very Schengen evaluation body concluded already in 2011 that Bulgaria and Romania made sufficient progress in the fields of data protection, police cooperation, visa issues, land, sea and air borders, and the Schengen implementing system. So neither the Accession Act nor the relevant secondary legislation on the Schengen evaluation include any additional criteria. which suggests that the legal criteria for full application are fixed rather than adaptable. The question then is, what are the legal implications that follow from that? Does the Council in particular have an obligation to adopt a decision if the criteria are met, or is the decision of the Council a purely political one? For the sake of brevity, I would say that the criteria are first legally binding and that they're also justiciable by the Court of Justice. For a variety of reasons, the wording of Article 4.2 of the Accession Act, the structure of rights and obligations in the Schengen Acquis, and institutional considerations, among others. I would gladly explain that, if need be, further in the Q&A. Thank you so much.
Thank you very much, Mr. Salomon. Then I would say that naturally now we could open a moment for Q&A, but as our next member of panel will have to leave till 3:30, we will give her immediately the floor. Yes, Mrs. Espelt-Gilt, Jean Monnet Professor ad Personam at Queen Mary University of London and at the Radboud University in Nijmegen, the Netherlands. She will present the topic, and then naturally we'll have Q&A related to these three interventions. The topic is the appeal to exceptional situations as means of reintroducing border controls within the Schengen area, the case of blocking border crossing on the grounds of public health concerns related to COVID-19 pandemics, cases such as the separation of spouses in Germany and France, as well as general movement limitations in Belgium. So, Mrs. Gild, I would give you the floor for 10 minutes, and I would ask you to be strict on this in order that we have 15 minutes of debate. Thank you very much.
Here and to be invited to present on this particular issue, particularly the problem of the exceptional situations and public health concerns in respect of COVID-19. I have very much appreciated the mise en scène by my two preceding speakers, who have covered a lot of territory, which means I can focus very specifically on the issue which is of particular importance here. One of the things which neither of my preceding speakers have commented on is the right in Article 21 of the Treaty on the Functioning of the European Union of free movement of persons for EU citizens and, of course, their family members. Now, we have had a very good explanation of the reintroduction of temporary Schengen border controls within the Schengen states over the last period and the particular problems that we've had since 2015. I would add that in 2020-2021, we had another set of problems in respect of free movement, which affected EU citizens infinitely more profoundly than a number of the other, the introduction of exceptions under the Schengen Acquis. In particular, the limitations to try and prevent the spread of the pandemic and the EU's response to that challenge to free movement of EU citizens concerned not only Schengen, but also the fundamental right, the fundamental freedom, one of the four pillars of the European Union, contained in Article 21 of the Treaty on the Functioning of the European Union. When a number of member states, and it certainly wasn't all of them, but some of them, introduced intra-Schengen, intra-member state border controls to prevent the spread of the Schengen virus, a measure which has had well, it was not shared by all EU governments that this was going to be an effective measure, and it was not a position shared by all of the health authorities. But the first question was the legality. And under free movement of persons, under the Treaty on the Functioning of the European Union, the only exceptions are public policy, public security, and public health, but public health limited to public health threats under an annex to the World Health Organization treaties. COVID-19 was never added to that annex, therefore did not constitute and has never constituted a ground for preventing free movement of persons within the European Union. Within the Schengen implementing measures that we've heard about from our previous speakers, the limitations do not include public health. So from the very first introduction of intra-member state border controls on persons in respect of health issues, we have a problem of a lack of legality under Schengen, which the new package proposes to change, and a lack of legality under Article 21 and the implementing measure Directive 2003/38. This was commented upon by the EU Court of Auditors in its 2022 report on measures taken in respect of COVID-19, where it noted that there were severe problems in respect of the legality of measures adopted to prevent movement of persons, and criticised the European Commission in particular for its failure in oversight. Now, every time we introduce intra-member state border controls, this doesn't necessarily affect everyone similarly, and I think that Dr. Solomon has indicated this in particular. It has differential impacts in respect of which parts of the population are considered to be problematic in respect of crossing internal Schengen borders. When there are no controls on internal Schengen borders, everyone passes, and the question of their legality in the state where they arrive is a matter of national law. When border controls are reintroduced, we see a variable geometry in respect of who gets controlled and under what circumstances. Particularly in respect of the subject that I am looking at, that is the separation of spouses, we can see that the reintroduction of border controls at intra-Schengen borders, which has consequences for the free movement of persons under the Treaty on the Functioning of the European Union, has a negative effect, or may have a negative effect, in respect of particularly third country national family members of EU citizens who are exercising their treaty rights to move and reside in another member state. Schengen law has nothing to do with family reunification. It doesn't cover it. It's not relevant. It's about abolishing border controls. Article 21 TFEU and Directive 2004/38 provides an entitlement, a right, of mobile EU citizens to move, to join and accompany by their third country national family members anywhere within the EU and indeed into the EU. The difficulties we've seen, and we can see this from the case law of the Court of Justice, from which member states do we have problems in respect of third country national family members seeking to accompany or join their family members. We can see that the countries suggested in this, recommended in this particular question, Germany, France, Belgium, but in particular also the Netherlands, are among the member states where a very substantial amount of the case law in respect of the entitlement of EU citizens to move and reside with their third country national family members has come into existence. The reintroduction of temporary border controls under the COVID rules had the effect of providing a new mechanism, a reintroduction of border guards at member state borders, which reintroduced and permitted the questioning of third country national family members of EU nationals moving perfectly lawfully, exercising their rights under the treaty to move and reside with their EU national principal, and under the guise of a dubious ground of public health, increasing obstacles on the basis of the street-level bureaucrat application of particular concerns in respect of third country national family members became an important obstacle for families to be together and to reside together. This was not the intended consequence of the reintroduction of limitations on free movement on COVID-19 grounds, but it was an unexpected outcome of that particular new power, the reintroduction of border guards at these borders, and the existing tendency in a number of member states to view third country national family members as necessarily requiring extra consideration, examination, interrogation, and being blocked at internal EU borders. Thank you very much. I think I've filled my time.
Yes, indeed. Thank you very much. A very interesting presentation. Then probably, if you allow me, we open the floor. I would urge each member or that wants to take the floor to be very strict, only to put their question or remark. As far as I see, we have already some colleagues that asked for the floor, and so I would give you, I'd say, 1.5 minutes per person, so much as the plenary, to put your question in order that then we can give to the three panelists the opportunity to answer. So I would start with Emil Radev and then our colleague Grappini. Well, so we'll have one per group now.
Okay.
Emil, please.
Благодаря, госпожо председател. Господин председател, уважаеми колеги, хубаво е, че днес отново обсъждаме темата за шенгенските граници. За съжаление, 8 години.
Thank you very much. Unfortunately, 8 years down the line, we continue to go around in circles. Instead of thinking long and hard about a solution or thinking about how we can defend our external borders better and
Thank you. It is good that we are discussing the issue of Schengen borders, but now, 8 years after the last major migrant wave, we are still in this vicious circle. I'm a representative from Bulgaria, and I should like to stress it is extremely important that Bulgaria and Romania should be accepted in Schengen. Our two countries have historically always been the gateway to Europe, and for the last 12 years, they have certainly met all the requirements for membership in the Schengen area. This is shown by a number of on-the-spot checks, various studies, reports, and it is well known in Parliament. It is something that the European Commission knows, something that the Council knows. So both countries should actually be accepted, and they should be able to receive this deserved place and the respect that their citizens deserve. We should not create new factors that only contribute to anti-European sentiment.
On behalf of S&D.
Mulțumesc foarte mult.
Thank you very much. I want to thank our three panelists, and I want to especially thank Mr. Solomon. From a legal point of view, he presented very interesting things that we were aware of, but I think it was very important for someone like him, a neutral person with legal background, to also highlight the important points here. I have a question, if time allows. You mentioned costs, direct costs, indirect costs. You also mentioned that, as we all know, Romania and Bulgaria fulfill the conditions starting from 2011. They fulfill the conditions. There is a commission which checks if the technical conditions are met, and this commission has given its positive opinion of this, but then the voting council was negative. Now my question is, what is the purpose of this evaluation? If there is an assessment, and if all Schengen member states were admitted into the Schengen space based on this technical assessment, then why do we now face a double standard? Why are things different now? And what solution would you see to this? Now, regarding the presentation from our distinguished Professor Gild, we know that movement was limited, highly restricted during the pandemic on shaky legal grounds. We now understand that the World Health Organization is working on a new circulation certificate. In your opinion, do you think that, given our experience with the pandemic, we may be able to prevent any such restrictive measures being taken again to restrict circulation?
To our colleague Stefaratu from Greens. Because you haven't asked for the floor, did you? Okay. Yes, no. I apologize, but here in my notes I have not your name. So we'll start with Mr. Gheorghe, and then we'll move to our colleague from Greens. Please, on behalf of Renew.
Thank you, Chair. I'll switch to Romanian now, so prepare your headphones. Am auzit mai devreme.
Thank you. We listened to the Commission representative telling us about the history of the Schengen space and how this was established, namely that the citizens from Western Europe no longer wanted to wait in line at the border. They found it pointless. The Commission representative also said that there was an assessment of the financial impact for the countries in Western Europe. This was happening 30 years ago, before I was born. And as a result of this assessment and based on the conclusions, they decided to no longer have border controls. Nowadays, Romania and Bulgaria are unfairly kept outside of this Schengen area. So now my question is, if citizens from Western Europe did not enjoy waiting in line for border control, why are we supposed to do that? If Austria likes to keep citizens waiting in line at the border control, why don't they do that to their own citizens? And if they want to control their own borders, why are they acting on our borders, on Romanian borders? The right to veto was meant to cover cases when a country's legal rights were infringed upon. So what is the link between Romanian citizens, Bulgarian citizens, and what happens at other people's borders? So if they want to keep their borders closed, they can close the borders between them and Germany or Italy or whoever they want, their friend Orban, for example. But they can stop meddling in our business. You made a very good legal analysis regarding the financial losses. Now, can you give us some details regarding compensation for these losses? Because we are heading that way. Thank you.
Thank you very much. And now, colleague Stefanociu.
Doamna Ulrich, domnule Dr. Solomon, Professor Gild.
Dear guests, you all three mentioned the same thing, namely that we're not talking about legal criteria here, we're talking about politics, namely that Romania and Bulgaria are kept outside of the Schengen area based on political grounds and not because they infringed any kind of law. On the contrary, they fulfilled all the criteria, and they have fulfilled them many years ago. And now you're telling us that we have a problem in Romania. No, I believe that you have a problem, political problem. Because members of the EU do not comply with EU legislation. How do you think Romanian citizens will vote next year in the elections? How do you think they will feel about the EU if it cannot tell its own citizens that they do not respect the law? No, we don't have a lot of activity during electoral times. So how are you going to act this year to change people's opinion? Because I appreciated that you mentioned you support Romania and Bulgaria joining this year. So how are you going to change people's minds? How are you going to change the mind of Mr. Nehammer, who keeps insisting that he will keep us out of the Schengen area? Please also go into more details regarding this article, namely Article 4, Paragraph 2, because it's very important for Romanian people to know more details about this. And this has to be done this year. And finally, let me say that many couples were kept apart because of borders. And this concerns people in Western Europe as well, not just in Eastern Europe. You just quoted Sienkiewicz, who wrote Vovadis, the novel. And he's an Eastern author who looked towards the Western world. How do we defend all our rights?
Okay. Now, Mep Teres for ECR.
Thank you so much. I will go straight to the point. One of the fundamental values of the European Union is the so-called rule of law. So every law has to be written on a paper and published in an official document, and this is the protocol of accession of Romania and Bulgaria to the European Union. Article 4, Paragraph 2 of this document clearly states that when these two countries are fulfilling their obligations, they have to be accepted into Schengen. Now we have multiple resolutions of the European Parliament, multiple communications from the European Commission, and official positions of the consuls, all of them clearly stating that both of these countries, not since yesterday, but since 2011, fully respected, I would say, all the conditions to be part of Schengen. So the first question that I have to our guest here, Stefan Solomon, is can you consider that the rule of law is respected in the European Union if these two countries, despite the clear fact that they respected the conditions to be part of Schengen, are still kept outside of Schengen? The second question, we were talking about compensations and a lot of direct or indirect costs of the fact that these two countries are outside of Schengen. So the second question is, who should be liable to these two countries and compensate their losses for the fact that their rights are not fully respected? And nevertheless, the third question is, what exactly can be done immediately that these two countries should be accepted into Schengen immediately? Thank you.
Thank you very much. Now, ID. Yes. No. ID, we don't have nobody. The left, nobody. Non-attachment, Ms. Danoka. Yes, second round. Yes.
I'm here. Thank you. Yeah, with full support of Romania and Bulgaria problem, and
we have just.
I want to touch another question which was raised. It's reintroduction of control on interior borders, and ask to Mr. Stefan Solomon his estimation of what would be happened if Schengen Border Court would be approved just as it was proposed by the Parliament. At that time in Libe I was co-rapporteur on this question, and our position was just to give more powers to Commission, not just allow Member States themselves unilaterally to introduce this border control. And the file was frozen. We had a big quarrel with the Council, which did not want such rights to Commission, and we know what has happened within COVID, when we had to step down and the Council's position was finally approved in the
border code. Maybe, Mr. Solomon, it would be interesting to calculate also expenses if our just European approach to this reintroduction of border control would win.
Thank you very much. Now I have 3 MEPs in the second round, but I have a problem that Ms. Gill, expert, she has to leave. So I'm going to give to her the floor to answer. Then I'm going to give again to the 3 MEPs in the second round, and then to the Salmon expert and the European Commission. Okay? So now I'm giving the floor to Ms. Gill.
Thank you very much. And I'm terribly sorry. I did let everybody know that I have an unmovable obligation that I'm going to have to leave. There's only one question which has been addressed to me directly, which is the attempts by the World Health Organization to resolve the problem of circulation under COVID, under pandemic situations, to have some kind of worldwide mechanism. And I think it's an excellent idea, absolutely necessary, but I think that we can go further within the European Union. We know from the reports produced by the Commission that most of the restrictions on movement within the European Union and within member states were designed specifically to save our health experts and our hospitals from being overwhelmed by too many cases all at once. And I think if we look at the question of how we adjust our public health services to be able to respond to pandemics, rather than to locking everybody down and putting huge costs on the economy, we might be in a better position to enable continuing free movement, irrespective of a pandemic, and deal with health issues in accordance with health law. But I'm very much in favour of the WHO proposals. Thank you very much. And sorry.
Saying sorry. Okay, thank you very much. Now I have 3 more MEPs in the second round. Ana Miranda, Greens Group. 1 minute, if it's possible, because
Grupo Verdes ALE se llama el grupo. Grupo Verdes Alianza Libre Europea. Verde.
The Green Group, European Alliance. Thank you all for the presentation. And as you know, this committee received hundreds of petitions, many of them signed by a huge number of citizens. Understand the situation, but they want to know why the council is persisting in the fact about the Schengen acquis and about complying with all the criteria and so on. Isn't paying attention. The council isn't. So the Bulgarian and Hungary are implementing the acquis. This has been confirmed by the experts group and the conclusions of the Council in 2011. More recently, the fact-finding missions in October 2022 found that Bulgaria and Romania had continuously applied the acquis since 2011. And the Commission's communication of November 2022 also called on the Council to make the necessary changes to this, to end this discrimination, which, as experts have said, has personal consequences, environmental and economical consequences, inhuman, and it's borderline illegal because it doesn't have the legitimacy in terms of connecting Europe, connecting people, connecting persons, and avoiding discrimination, which is one of the reasons that Europe exists. You have to finish. I am finishing. The Parliament adopted a resolution, but the question is for the experts mainly, and is, do you see any possibility of any measures that could be taken into account to facilitate this right to free movement for the citizens of Romania and Bulgaria? Thank you. Thank you. Now, Mr. Dambaski.
Thank you, Madam Chair. I have a direct question to our experts. What is the impact on the environment when hundreds of thousands of trucks have to wait on the borders between Bulgaria and other countries? How many tons of harmful emissions, for instance, since you're usually preoccupied about this? 12 years have passed. For these 12 years, we have covered all the criteria. 12 years are a very long time, and we have heard many nice words for these 12 years, but we still haven't been admitted to the Schengen area. And the reasons for this have mostly to do with the economy, with transport, with logistics. The port in Rotterdam is the largest port. But when Bulgaria and Romania are going to join, then we'll have Constanța, we'll have other ports that will compete. And this is the reason why many do not want Bulgaria and Romania in the Schengen area. We have covered all the technical specifications, and yet there are various reasons that are quoted why Bulgaria and Romania should not be in the Schengen area. Our truck drivers have to wait on the borders. They have to live without their families because most of them live abroad, and they're used and employed abroad but not in their own country. Thank you.
El diputado Comín.
Comín.
Sí, gracias, presidenta.
Thank you. I would like to speak Catalan, but
¿Puede volver al orden
la oficialitat del català, faré la intervenció.
I have to call you to order, sir. You know perfectly well what the official languages are.
Feta la denúncia, sí, no.
So I'd like to draw attention to the fact of Catalan not being available. But it's about the blocking of the borders between Spain and France, which borders Catalan territory, with the reestablishment of controls during the COVID period. France has been breaching the Schengen rules, has been blocking a lot of borders. And it justifies this with all sorts of excuses, terrorism and so on. And it's causing grave inconvenience in Catalonia for trucks and for thousands of families on both sides of the borders. And France shows no sign of changing tack, even after the Court of Justice having ruled that these restrictions are contrary to the Schengen Code, because they exceed the time limits allowed. So we would like to call on the Commission to act to have the borders to Catalonia reopened and to reform the Schengen Border Code, to take the necessary measures to ensure that one of the pillars of the Union, which is the free movement of citizens, is complied with by citizens. Your time is up. I'd like to finish in my own language, which should be an official language.
Perfecto. Pasamos la palabra.
Now, let's move on to the experts.
2 minutos tiene el experto.
2 minutes for the expert.
Thank you so much. Well, let me start with the comment that was given by the truck drivers. When the Saarbrücken Agreement, which was the predecessor to the Schengen Agreement, was concluded in 1985, it was actually, the impetus for the conclusion of this agreement was actually truck drivers, German truck drivers, Austrian truck drivers, and other truck drivers in Italy, which basically blocked the roads and therefore demanded political action to finally abolish the border controls, which had been promised in prior EU documents. So I found this a very telling anecdote. And back then, the political leadership in Germany in Bavaria actually supported the political action of the truck drivers by providing them with food and beer. What was otherwise an illegal action. So let me answer the questions in the order. I basically summed them up a bit. So The first point was, the first question basically concerns the veto of Netherlands and Austria. And what's the purpose of this veto? Well, the purpose of this veto is that the Council verifies that the technical standards which had been adopted by the Schengen evaluation body are actually fulfilled. So it's really a verification mechanism. So the Council decision would then be the legal basis for the full application of the Schengen acquis. What if 2 or more member states block it, although the Schengen evaluation had been fulfilled, and this is not, and the criteria in the Schengen evaluation has been fulfilled, and this is actually not contested, but other criteria are cited? Well, the solutions to this, I could only, the political solutions, I don't know. I could only point you to the legal options and which kind of legal options do exist. So if the Council does not adopt this decision due to some member states blocking the unanimous Council decision, there is always the possibility for a member state or for another privileged applicant, such as the European Parliament or the Commission, to bring an action for failure to act in Article 265 of the TFEU against the Council. The second point basically concerns the compensation for losses. Well, I guess we need to distinguish there the compensation for losses suffered by Romania and Bulgaria, and the and losses suffered by citizens because of border controls which are currently still in place by and maintained by Austria, Germany and other states. As to the second point, there is always the possibility of state liability, and you basically, the conditions I would see fulfilled. So a citizen, an EU citizen who has suffered a loss because of, or a company which has suffered a loss because of waiting time at the internal border, because of border controls, can always go to national courts and claim the compensation for the losses that they suffered. I do not see this possibility in Bulgaria and Romania currently. And the third question concerned the EP, the European Parliament proposal. So the European Parliament proposal, grosso modo, maintains the legal framework as it is, in the sense that border controls would still have this exceptional nature. The Council and the Commission proposal sees this a bit differently, and it would basically envisage to reintroduce controls more as longer-term measures to counter longer threats, which would then shift border controls from more exceptional measures into longer-term measures. If the EP proposal is adopted, and the...
Excuse me, but you have to conclude.
Yes, I conclude by saying basically even if the EP proposal is adopted, the Commission, what is still needed is enforcement by the Commission in addition to the enforcement actions that are by EU citizens. There is a concern by citizens as the petitions clearly show. However, the fact that EU citizens do not take legal actions is often, the reason for this is often the costs of the procedural costs that are involved with this. Thank you.
Thank you very much. Now I'm giving the floor to the Commission.
Thank you very much. Very briefly, on the internal border controls, both those that had as a reason COVID-19 and the current border controls that are in place. It is correct, as Professor Gill said, that we don't have a special public health reason in the Schengen's border code. However, we had the public policy and we have the public policy reason. And as was also mentioned, in view of the danger that our health systems were in at the time, the Commission considered it legitimate to put internal border control in place at the very beginning of the pandemic. Further then, we coordinated a lot of measures in order to get these border controls lifted quickly, and we achieved this relatively fast. However, and this is also something that the European Court of Auditors acknowledged in its audit, the Commission didn't have the formal powers to do anything. This was all done on the basis of free floating coordination work and the goodwill of the member states. And this is why we proposed in December 2021 a review of the Schengen's border code, which at the moment is being considered in the LIBE committee, in order to make sure that in a future similar crisis, we will have the appropriate tools at hand. The same goes for the internal border controls that are in place at the moment for other reasons, for a reason of terrorist threat and for secondary movements. Again, the current proposal aims to address these shortcomings of the current Schengen's border code. At the same time, as long as we don't have the revised Schengen's border code in place, the Schengen coordinator has made very strong efforts in order to enter into a dialogue with the member states concerned. Since October, there are regular meetings in order to find ways to lift the internal border controls in place, and this has already been achieved with a view to the controls between the Czech Republic and Austria on the one hand and Slovakia, and between Denmark and Sweden. On the accession of Romania and Bulgaria, Mr. Solomon has already said a lot. Now, what has the Commission been doing? The Commission has been, since 2011, continuously advocating for the accession of Romania and Bulgaria. We organized last year, and we thanked Bulgaria and Romania for their availability to do this voluntary evaluation mission, just in order to confirm the results that we had in 2011. And as a result of that, the Commission issued in November 2022 a communication, again emphasizing its conviction that Romania and Bulgaria are ready for the accession and asking the Council to proceed with this. My commissioner personally has been involved during the entire mandate in discussing with member states this. She's been very, very active last year, and she continues to be active. And as I said, we're now working very, very actively with the Spanish presidency in order to make sure that the decision can still be taken this year. Thank you.
Muchísimas gracias. Pues ahora
Thank you very much. And now we move to the second panel. We have Mr. Zhao. He's going to make a presentation on his vision of the appeal to exceptional situations.
Introducing borders controls within the Schengen area. The case of Germany keeping controls with Austria for years, and the case of Denmark introducing border checks with Germany and with Sweden for migration regulation proposed. So thank you very much and welcome, and you have 10 minutes.
Thank you. I prepared a presentation, which I hope you can all see. And thank you for giving me the opportunity to address 3 important petitions that concern the reintroduction of temporary border controls between Germany and Austria, Denmark and Germany, and Denmark and Sweden, which have been in place for several years. Based on my research, I will address first the use of temporary border controls over time, and then secondly, I will focus on the cases mentioned in the petitions. But let me firstly go swiftly over my introduction, and I also need to note that my view does not necessarily reflect the position of my employer, the Expert Council. Next slide, please. As we already heard from the previous presenters, the Schengen area is a cornerstone of European integration, with considerable economic, Mr. Salomon addressed this, social and also symbolic significance. So let me just say that I think it's quite understandable that citizens and economic actors are concerned when temporary border controls are in place for an extended period of time. Next slide, please. The Schengen Border Code enables member states to reintroduce temporary border controls in specific cases, which you can see on the slide, but I'm sure you are aware of, but only limited for a fixed period of time and as a last resort measure. I think that's pretty important. In my view, temporary border controls, please one slide back, sorry. In my view, temporary border controls can be seen as a pressure release valve that is supposed to safeguard the Schengen area in specific circumstances. But how are temporary border controls actually used? Next slide, please. Looking at the figures on the right, you can see the number and average length of temporary border controls over time. On the top, it's the number of borders, land borders affected, and below you see the average number the length of the temporary border controls. And it's apparent that for a long time, temporary border controls were used as a flexible, short-term solution to fairly circumscribed issues, like political meetings or sport events, for instance. But clearly, since 2015, something changed. Temporary border controls are now used much more often and also for a longer period of time. There's really been a strong shift. We can also see that temporary border controls are most widespread at the beginning of crisis events. And we've already heard about the migration crisis of 2015 and 16 and the COVID pandemic, which was addressed by Ms. Gild. Next slide, please. Let me now say a few words about the reasons that member states give to justify the reintroduction of temporary border controls. The figure on the left shows the main reason for the reintroduction of temporary border controls over time. In sum, the reasons changed considerably, from the protection of circumscribed events, such as sport events, to immigration control, the prevention of terrorism, and recently mixed motives and overlapping motives. We can also see and learn from the figure that there are several heavy users of temporary border controls. These are member states in the North and Western Europe. In particular, Germany and Austria. Germany kept temporary border controls since 2015, so 9 years by now. Denmark and Germany since 2016, so 8 years. And Denmark and Sweden since 2018, so for 6 years. And scholars underline that the multiple extensions, which add up to several years of temporary border controls, mean that they have become quasi-permanent. So they are not a temporary measure anymore, but a permanent measure, or one could say the new normal. Next slide, please. Looking at the cases mentioned in the petitions, we can see that since 2015, major events are invoked to justify temporary border controls. These are refugee movements, so-called secondary movements, in the case of Germany and Austria. The pandemic, of course, also for several years. And in the case of Denmark and Germany, it's a mixture of migration, organized crime, and terrorism. And by now, also other reasons, for instance, the war between the invasion of Ukraine by Russia. And between the border Denmark-Sweden, it's mainly organized crime and terrorism. The mixture and overlapping reasons make it really difficult to assess the effectiveness and proportionality of measures. It's also difficult to determine whether temporary border controls are an appropriate response to the respective threats, because measurable objectives are rarely established in the notifications provided by the member states. At the same time, we learned that temporary border controls entail measurable economic costs. And I would also like to add that they also might harm European integration, but also European identification for people traveling across the borders of the Schengen area. Next slide, please. So I come to my conclusion. Since 2015, temporary border controls at intra-Schengen borders have been prolonged for multiple times, and at the moment, I think it's fair to say that they lost their temporary nature and have become quasi-permanent. What is more, the reasons are no longer specific events, but instead mixed motives and major crises, but also mixed and overlapping reasons are given by the member states. And the mixing of motives and reasons that are mentioned make it really hard to assess the proportionality and effectiveness of the measures. I can't delve into detail here, but let me also mention that the resort to temporary border controls are of course also related to larger problems affecting the whole Schengen area. For instance, the first country of entry principle that where we currently see several deviations, which is enshrined in the Dublin regulation. Next slide, please. You can see some of the literature I used in my presentation. And next slide, please. Let me thank you for your attention, and I'm looking forward to the Q&A. Thank you.
Thank you very much. Now I'm giving the floor to Ms. Guillaume, that she is...
Merci, Madame la Présidente. Je suis membre des...
Thank you very much, Madam Chair. I'm a member of both committees, Peti and Libe, and I have to tell you that there are two very different atmospheres for each, especially when it comes to the matter of Schengen. Many of the things I wanted to say in my introduction have already been said, but I just wanted to say that in December 2021, the Commission came forward with its proposal to modify the Schengen Code. Why was a reform necessary? This has already been mentioned, but Schengen has faced a number of challenges in recent years, whereas it represents, from my point of view, and I can imagine that this applies to a large number of members of these two committees as well, that it's one of the biggest achievements of the European project, a single space that allows millions of passengers to travel freely. Since 2015, as we've just been reminded, this freedom of movement has no longer been assured between certain member states. Some of them, such as France, Germany, Austria and Sweden, have decided to reintroduce checks at the border for various reasons that we've heard about, terrorism being one. When it's functioning normally, the Schengen area might also reintroduce internal checks for a maximum duration of 6 months, and I have to insist upon that point. We also had a reminder of this in 2022 by the Court of Justice, and yet a number of member states still have checks in place for years, and that wasn't mentioned by the last speaker, but France as well has had them in place for 7 years, domestic checks. The Commission could have launched infringement proceedings, but it has not done so. It's preferred instead to adapt the rules of the code. And, as we already just heard about, it's tried to sort things out face to face. There are several elements that have been proposed by the Commission as part of its revision process which have seemed problematic. Firstly, the Commission decided to introduce into the text the definition of the instrumentalisation of migrants. As a reminder, the Commission has proposed a specific regulation against instrumentalisation of migrants. I believe it's still under negotiation, with a view to responding to the situations as faced by Belarus in 2021. So that this is not then punishing migrants, so that they're not victims of this regime. But on the other hand, there are problems with the definition of asylum and migration, and they have no place in a text that deals with managing this internal zone. Another contentious point is the Article 23A, which introduces a first proposal about member states. It's not relevant to add new procedures to internal borders when we still have very vague contours. It seems that the Commission has tried to resolve the problems linked to migration, which were not regulated in the text on the subject. And Schengen is not there to make up for shortcomings in other aspects of European legislation. In the revision of the code, the Commission is also proposing to revise the Returns Directive as well, which would allow member states to sign new bilateral agreements on the subject. That runs counter to what the European Union aims to do and is counter to the principles of Schengen, which, as I've said, requires there to be no checks carried out. In addition to the ones that I've just mentioned, introduction of this migrants as being a reason for getting rid of internal checks does not hold up. For example, if there are threats against domestic security, that would be a reason, but in reality it's being used to counter migrants moving. And another reason for reintroducing checks as well has been happening without these exceptional circumstances, and the Commission has authorised that for 2 years already. As you can say, I haven't really mentioned the Commission. I haven't really bathed the Commission in glory in this opinion, but I believe that Schengen is of such vital importance to the European Union that I had to present it in this way. And that's why in this draft report that I submitted in November 2022, I really wanted us to revisit the original spirit of Schengen. No controls. I suggest that reintroduction of these checks by member states should be of last resort and for a specific period of time, and sometimes I think that we really need to say this again. I've got rid of Article 23A, as well as the definition of instrumentalisation, and also using migration as the reason for introducing checks again, and also the recasting of the Returns Directive. I wanted to grant a greater space for the Parliament and the Commission to do what is necessary, which will allow us to put an end to these multitude of checks that are happening. Some of them have been placed in place for a number of years. And we've also drawn on the 2022 Court of Justice ruling as well, which seems to be in keeping with this view. To end on a positive note, I would support the Commission when it comes to how the pandemic was mentioned, and that's already been mentioned by a previous speaker. In January of 2023, those checks were still in place, however, and as you might have seen, they are rather complex. During these negotiations, there are two different visions of Schengen facing each other. Part of the hemicycle seems to be very focused on opposing this report that I've proposed, and this has drawn out the negotiations for quite a long time. However, there seems to be an agreement on the vast part and the majority of the text. There are 2 points that need to be sorted out: internal returns as part of Article 23A, and also returns as part of exceptional circumstances, including crises. A number of concessions have been made, I admit. I've worked on a number of compromises on these articles, but despite the scepticism that I feel in this matter, that article now comprises that the procedure and putting in place sufficient safeguards to be accepted, it seems to me. As far as the duration of controls are concerned, I consider it impossible to accept internal checks on an unlimited basis as determined by the member states, because this runs counter to the spirit of freedom of movement that we've already talked upon, and also it contradicts the decree of the Court of Justice. We've often spoken about rule of law, and that must absolutely be respected, and we have to respect the decisions made by the court. I hope that we are going to find a negotiation that will allow us to negotiate an agreement by the end of the mandate. And to conclude, I would just like to say that in the past 10 years, we've seen that it's much easier from a political point of view, because of national political sensibilities, to reintroduce these internal checks. It's much more complicated, however, than making that decision to lift them afterwards, doubtlessly because of public opinion on the matter. It's not the role of the European legislators to introduce additional instruments that allow them to justify the reintroduction of internal checks. I think we need to revisit Schengen and make sure that it corresponds to the Schengen spirit. Thank you.
Okay, thank you very much. Now we have questions and answers. So let's start. EPP, nobody wants to say anything. So Yana Tom.
Thank you. Thank you, Chair. I don't know if the speakers from the previous round already went away, or maybe somebody of them stayed, but I just wanted to ask to whom it may concern, like we sometimes write. Nobody mentioned external borders. I understand that this is kind of a bit different issue, but we also have different rules there. I mean, in September 2022, for instance, my home country, Estonia, Latvia, Lithuania, and Poland introduced visa ban for Russians, which is absolutely different from visa ban introduced a month later by Finland, and very different from a visa ban introduced by other Schengen countries, which gives very bad impression when you look at Schengen area from outside. And people who know that they would not be let in from, let's say, Estonia, they go via Finland, if no Finland, then they go to Italy. And of course, if we have this set of different rules for the people coming outside, it's obvious that we are kind of feeding the need for internal border checks. So maybe somebody can also reflect on that. We wrote to Commission, but frankly speaking, we received very long and very empty letter out of here. Thank you.
Okay. Ms. Auken.
Yeah. No, I take it in English, Danish in the next, when we have the petition next time on this issue here. But I'm just, I'm really a little bit confused. Is it possible for the Commission just to change the laws? You said, because Denmark was for good reasons really accused of violating the Schengen rules when we just copy-pasted the old argument for prolonging and the border control. And in Denmark, it's absolutely, the police is opposing what's going on because they say it's waste of money, it's waste of time, it's waste of resources, could be much better used if you want to combat crimes and get these groups here. Then we have all the issues with of course, with the pendlers in this region there. And I think it was said quite clear that it was a clear violation of the Schengen rules. But no process has been opened. And you say I'm not very loyal to my country. Yes, I am loyal to my country, which is really badly ruled on this issue here now. So I'm defending my country, doing very idiotic things to a very important region for us, which is Schleswig, South Schleswig, North Schleswig, but it's also the waste of resources. Why is the Commission not doing anything about it? Thank you.
Thank you. Somebody else wants to intervene because I don't have any more floors. Yeah, I know. But nobody. Okay. Now we have here the former MEP from Lithuania. But first, I want to ask if the rest of the MEPs they have any problem if it's taking the floor. No. Okay. So go ahead. Yeah.
So, as it was hearing, I just wanted to say about the situation on the border. External border, and with regard to the visa facilitation agreements, which are not in the hands of the countries, but my question to experts, who is in charge for the Schengen Code implementation at the European Union level? Because the Commission is saying that it violates the code every time when it wants, without consent of the member states, and Parliament keeps silence. The situation looks like that. In Belarus, Wagner Group, paramilitary group, is setting a campus, and according to visa facilitation agreement, Belarus citizens can enter European Union at, let's say, very facilitated rules. So it means that paramilitary groups, Schengen, can enter Schengen, Lithuania, because Belarus could issue them documents into our territory and also into the territory of the other member states. So who is in charge for the visa facilitation agreements and to the how to implement the strictly prohibited entry of the European Union without interactions of the European Commission, and only citizens who are not allowed to enter Schengen zone are from Romania and Bulgaria, as I understand, because if you are from that country, Russia, Belarus, Ukraine, there are no borders there. There is just documents are issued by anybody, nobody cares, it's chaos, just chaotic situation, and they all can enter under different regulations issued by the Commission.
Okay. So now I'm opening the floor to the experts. Let's start with Mr. Gulzau.
Thank you. Just a few more notes. Of course, from the beginning, the abolition of border controls intra-Schengen at intra-Schengen borders was related to the hardening of the external borders. So there's a strong relation between the two. But and at the same time, member states justify temporary border controls by secondary movements and also the missing responsibility sharing of asylum is an issue here. But at the same time, I would question whether internal border controls are an effective measure to address this issue. I think member states could do more to show that internal border controls are effective are an effective solution to this issue. And the second point, maybe the Commission could also issue an opinion on the notifications and ask member states to provide more information about the threat that they address with the internal border controls, and also put a burden of proof on them to show that it is an effective measure. Maybe small remarks.
Ms. Guillaume.
Non, je n'ai pas grand-chose à ajouter parce qu'il n'y avait pas vraiment.
I don't have much to add because there aren't really any questions. It's more comments on the subject. On behalf of the Parliament, I'm going to continue the work to try to find a joint solution. I can't be 100% sure that we'll manage it because we have very, very differing positions, particularly on the length of upholding the internal border controls and the reason for setting them up as well. But I do hope that we will continue to work in the spirit of Schengen, which is trust and shared work, and that's exactly what we're trying to do. Thank you.
Thank you very much. Now I'm giving the floor to Vice President in Libe, Paolo Rangel.
So, thank you very much, Dolores. First, I'd like to thank you, all of you, our experts that we invited, and members of Parliament and staff and others that really were so interested in this hearing. I'd like to apologize for being out for 20 minutes, 25 minutes for votes in AFCO. But then let me say, bearing in mind what I heard in the first part of the three main explanations of this hearing in the first part, and then also with some notes that my assistants sent to me, let me say that first, Schengen is clearly one of the pillars of the European Union, and I say that today everybody agrees that if you ask a citizen of Schengen area if he values this freedom of circulation, I'd say this is like Erasmus or like euro currency and so on, a clear symbol and advantage of being an European citizen. So this is a constitutional, I'd say, symbol of the European Union by one hand. Then second, I think that it's clear today that there is an abuse of member states using the internal borders control. So in some occasions it is totally, I'd say, reasonable to do it. If you have a big event like Olympic Games or football championship or something like this, a great initiative, of course there can be security reasons. When we had all these, I'd say, terrorist attacks in France or in Belgium, and so during some time this can be reasonable, but it cannot be a permanent answer, because then you are destroying Schengen. The simple fact that there is a permanent check at internal borders with suspension of Schengen for 6, 7, 8 years, this is clearly breaching all the system, because this is a disruption of Schengen. So we cannot bear as a system this kind of permanent exception. I have to say, and now I would move to two examples, one that was not referred here. It was referred as an example, that is the Swedish case. But we listened, me together with Mr. Lopez Aguilar, the previous government of Sweden, but the position is the same. And the argumentation was not really a good and sound one. Why? Because he was saying, if I look at organized crime, there is a direct relation with having controls at Swedish borders and to combat, diminish, reduce the activities of organized crime networks. And this is not an answer, because what we have to say to these countries is you have to choose if you want to remain or if you want to leave Schengen. Because you cannot have the best of two worlds. That is, I have my own controls, but then I profit from the freedom of circulation of all the others. And so this is something that we should really face. Then let me say that I don't agree with one of the experts that said that public health was not a good reason for creating an exception. So about COVID, that this was illegal. This is totally wrong in my view. Because we have in Schengen's Borders Code one exception for internal control, that is security reasons and relevant or very exceptional in public interests. And public health is an exceptional public interest. Of course, if you say, it's because cancer is not a reason, but an epidemic, not a pandemic, an epidemic can be a reason. Because inside our own countries, we have restrictions to freedom of circulation in our own countries. And this was at least common sense, and law cannot be against common sense. But even if it was not common sense, this is allowed, because what Schengen's Border Code says is, for external borders, public health is foreseen. But that is public health independent of any pandemic. If you go to the United States, if you go to Australia, if you go to China, you have to fulfill something where you say, I don't have this disease, I have this vaccine, I don't transport this kind of materials. So for external borders, you can use health even if there is no pandemic, only because this is your sovereignty. Of course, inside borders, you cannot use public health in this respect as a normal thing. But if you have a pandemic, this is a relevant, I'd say, a very relevant, exceptional case of public interest. And so it was not wrong. What was then wrong with exceptions during COVID times? It was wrong not to have something that the Commission, we have to be honest, proposed, that was a common criteria to establish restrictions. To say, if we have these pandemic numbers in this region, then we have this kind of restriction. If it is more the double, we have a kind of yellow, and then we have a kind of red region. So what we should have, it was a common criteria for restrictions, not to say to the countries, to the member states, you cannot put restrictions, but they should follow the same criteria. So sometimes they said you cannot come from Hungary because you have these numbers. But then Germany would say you cannot come from Austria because you have these numbers that were totally different. And so this was the problem. The problem is not to have restrictions with internal check control when you have a pandemic or an epidemic. The problem is that you don't have an homogeneous, uniform criteria for all Europe. To say, if you are a red zone, you can do it. If you are a yellow zone, you can do only this. If you are a green zone, you are not allowed to create this. And I have to say that the Commission proposed this to all the member states, to say we will have common criteria, and then you can launch the checks or not, according to the evolution of the pandemic in your territory or in your different regions. Because even it could happen that you could have internal control in some regions and not in others. And so this could work. So only to say that Of course, I welcome very much the proposals and the presentation made by Sylvie Guillaume, and I think really need a reform of Schengen Borders Code, but we cannot say that we don't have instruments to face exceptional situations. We have it. The problem today is the countries are using arguments, are using reasons that are not really covered by the law, and I have to say they are disproportionate because they are not necessary. As I said, sometimes we have, of course, sometimes we have situations where it is needed, very useful to have internal borders reinstalled. But you cannot prolong this for 7 years, because then this is not Schengen. This is a fake Schengen thing. And that's why I think that here we should be very strict. I understand that the countries sometimes imagine if there is a security threat, you need 6 months. Probably we can have to extend more 6 months in order to grant that everything is clean and now we have proper measures and everything is okay. But you cannot say, I have to keep these 7 years. You cannot say, I'm going to use these to combat organized crime. Because organized crime, we have to combat all over the territory of the European Union. So we have to have these measures in the external borders, not internal. And this is a bit strange because we are also in Libe working in a lot of police cooperation in order to combat crime. And we are giving to some, I'd say, authorization for exchanging of data that are sensitive, that are important, but that we say, okay, for this purpose, we will allow with guarantees and checks. So we are also creating a common space of security. And so we should not have these controls when we have liberty or freedom and security are always together. I have to say that if you look at the declaration, la Déclaration des droits de l'homme et du citoyen de 1789, there is the right to freedom and security together. And if you go to almost all the constitutions, they have these two. So they say, we understand to be free, you need to be safe. Look, in some Latin American cities, it's so insecure, so unsafe that people are not free. They cannot leave home freely, they cannot walk, and so on. So we need security, but this is a balance. And if you have a common space of freedom, you also have a common space of security. We are providing police authorities, member states, with the capacity to exchange data in this. So they have to comply with the freedom, the respect of the freedom of circulation, because they have the means and the instruments to check this at the European level and not only at local level. So I would conclude saying that I still have a lot of hope in Schengen, but we can do much better. And also that depends on our scrutiny capacity of the Parliament. I think that here we have a good role, and it was really a pleasure to see that our citizens all across Europe are worried with this, and they come to party in order to really try to fix situations that they know that are wrong. Thank you very much.
Muchísimas gracias. Ha sido muy interesante el panel y por tanto doy las gracias.
Thank you very much. The panel's been very interesting. So thank you to the panelists and of course to the Vice President of Libe. We'll all take into account everything you said to better take our decisions both in the Libe Committee and in the Petty Committee. We can move on now to the next.